Oyez, oyez, oyez. All persons having business before the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5101 et al. Center for Biological Diversity et al. Versus Liam Zeldin in his official capacity as Administrator for the U.S. Environmental Protection Agency et al., State of Florida and Florida Department of Environmental Protection appellants. Ms. Jaffe for appellants Cross-Appellees EPA et al., Mr. Street for appellants Cross-Appellees State of Florida and Florida Department of Environmental Protection, Ms. Reichert for appellees cross-appellants Center for Biological Diversity et al.
Mr. Jaffe, good morning.
May it please the court, Rebecca Jaffe appearing on behalf of the United States. I'd like to reserve 1 minute of time for rebuttal. The district court erred in holding that the Fish and Wildlife Service and EPA violated the Endangered Species Act, and the court should reverse. Fish and Wildlife Service and EPA complied with the Endangered Species Act in relying on a process-based approach called technical assistance to ensure that EPA's approval of Florida's State 404 permitting program would not jeopardize listed species. The agencies followed the approach that the Second Circuit upheld in cooling water intake, and the district court erred in rejecting that precedent. The approach here allowed the agencies both to support Congress's cooperative federalism goal of having states manage 404 permitting programs and also comply with the Endangered Species Act. It's important to understand the agency action at issue here. It was a one-time approval of Florida's application to assume permitting authority for all assumed waters across the entire state in perpetuity. In that context, EPA and the Fish and Wildlife Service simply could not know all the permits in all the locations and all the potential species impacts forever. So the agencies relied on species protective guardrails built into Florida's program.
I guess my question is, from what you just said, is you said they couldn't know that forever, but why doesn't that just mean you can't approve this under the Endangered Species Act?
Because, Your Honor,
Because the Endangered Species Act requires the agency to make certain, well, to look at all the data and to make certain findings about whether there's jeopardy or not. And that's based on baselines and effects, et cetera. So if it is the case that this program doesn't allow you to make those findings, why isn't the answer that this program is not lawful?
I have a couple answers to that, Your Honor. I think the first is that we have to read the statutes in a way to harmonize them, not to let the Endangered Species Act prohibit states from ever assuming 404 permitting authority, which is what we know Congress wanted.
My question, though, is 404 permitting authority doesn't have to take into account the Endangered Species Act at this stage. There are 2 other states that do this. And they don't have blanket take liability provisions under the Endangered Species Act. You can approve the 404 permit and just let the Endangered Species Act function independently.
Your Honor, and I do have one more response I want to go back to with the previous question, but I think both of those states, I mean, every state designs its program itself, and that's what Congress envisioned. And those states are very different states with fewer listed species. And also those approvals were quite a long time ago, where I think lots of things operated differently. But the question under the Endangered Species Act is, will there be jeopardy? And the Fish and Wildlife Service absolutely has to look at the best available data. Here, the best available data was we don't know, we can't know. So we'll look.
I understand that, but I guess going back to what we were just talking about, in terms of the Clean Water Act and the permitting authority, it doesn't speak to the Endangered Species Act. And what normally happens is you comply with the Clean Water Act and you comply with the Endangered Species Act. And you don't have to have one process that tries to comply with both. You can be doing your permitting as a state, Florida can be doing the permitting, and then each permit might have to comply with Section 10, or, I mean, Section 7 goes with agency actions these individual permits can't really come under Section 7. So it just seems that what Florida and the Fish and Wildlife Service were trying to do is to create a whole new thing. And I just don't see why everybody has to bend over backwards to allow them to do that when we have two independent statutory regimes which can very well function independently, and that's the way they're intended to function.
Your Honor, there is a federal action here, and that is EPA's approval of Florida's program. And EPA concluded that it had to consult under the Endangered Species Act. And that is
Because of the form of the program that they came up with, because correct me if I'm wrong, but under the Clean Water Act, for Florida to take this over, it doesn't mention the Endangered Species Act. It just has to have certain, I guess, the ability to have a permitting structure. It doesn't contemplate that the Endangered Species Act will be subsumed by this process that you come up with.
Well, the Clean Water Act does require that EPA solicit and review comments from the Fish and Wildlife Service. And it does require that EPA ensure that any state...
For individual permits, not for them to take over the permitting. That's not the way I read it, but perhaps I'm wrong.
Your Honor, at Clean Water Act Section 404G 2 and 3, the statute says the administrator shall provide copies of such program to the Secretary of the Army Corps of Engineers and the Secretary of the Interior, acting through the Director of the United States Fish and Wildlife Service. 404G3 says...
I'm sorry, but that's not part of the process of approving the state's ability to issue the permits instead of the Army Corps, is it?
I believe it is, Your Honor. 404G is about state administration. And then 404H lists the criteria for EPA to approve a state's program. And it talks about taking into account...
So I'm looking at 1344G, which is labeled state administration.
Yes, Your
And
Honor.
it says, the state may submit to the administrator a full and complete description of the program it proposes to establish and administer under state law or under an interstate compact. That doesn't talk about federal law or the ESA at all, right? That's G1. But I guess
Right,
the
right,
broader
but
point-
G2, Your Honor?
I'm just looking at G1, but I think that the broader point, though, I think, is that when a state wants to take over this permitting process under the Clean Water Act, it's not required at that stage to come up with a plan about how it's going to comply with the Endangered Species Act. And that's not what happened in the other two states. This is a novel thing that you're doing. Do you agree with that?
No, Your Honor, I beg to differ. Florida's program is structured differently than the other two states, but the 404G2 and G3 specifically refer to comments from the Fish and Wildlife Service. And then 404H, which has the criteria for approving a program, refers to taking into account the comments from the Fish and Wildlife Service, but also EPA must assure that the state can assure compliance with the 404B1 guidelines. And one of the 404B1 guidelines is that no permit shall issue if it will cause jeopardy or adverse modification of critical habitat. So when EPA is approving a program, it has to have some way of saying, are we meeting these guidelines? Are we sure that the state can issue permits that won't cause jeopardy?
It just seems to me that the default way to handle this, if we all agree that we have obligations under the Clean Water Act and we have obligations under the Endangered Species Act, is for, in each case, to make sure those obligations are met instead of in advance trying to come up with some program that gives blanket, take liability insurance to anything that's coming later when you don't even know what the specifics are going to be.
Your Honor, Florida has a right to design its program, and EPA has to review the program that is presented to it and determine whether it complies with the criteria, and EPA is taking an action.
You know, everybody, I agree with all of that. I just think that the action they're taking doesn't seem to comply with the Endangered Species Act.
Well, I do agree with the court that they couldn't know all of the impacts. And so here, the best available data was relying on the process. A process where Florida will submit every single permit to the Fish and Wildlife Service to review. Fish and Wildlife Service will propose various protective conditions that Florida must incorporate into permits. Fish and Wildlife Service will specify take limits for every single permit.
I don't want to take up all your time, although it looks like I have. I apologize to my colleagues, but I just have a final question. Do you think it would have been permissible for Florida and the Fish and Wildlife Service just to say, we approve this subject to later consultation that will definitely ensure that Section 7, the Endangered Species Act, will be fulfilled?
I don't know, Your Honor. I don't know what the later consultation would be because this is a
The
one-time
later
approval.
consultation will be, Fish and Wildlife Service will be involved. And we will definitely ensure that the Endangered Species Act will be abided by.
Your Honor, EPA is taking the action now. It's approving the action
I'm asking you
now.
a hypothetical. Could Florida and the Fish and Wildlife Service have come up with a plan where the plan was, we're going to approve 404 permitting by Florida now, subject to a commitment, a firm promise that we will comply with the Endangered Species Act in a process later to be determined?
I don't know, Your Honor, and I think there'd be a lot of questions about what is this process later to be determined. So here they laid out the process.
Correct, but the process doesn't specifically require compliance with each of the terms of the Endangered Species Act. It's basically saying we promise that this is all going to be fine. So I think that's exactly what happened in this case. It's very similar to my hypothetical.
I beg to differ, Your Honor. I don't think the process is sort of a, it'll be fine, don't worry about it. It's a very detailed, there are memoranda of agreement. Florida has codified the process in its regulations, in its 404 program handbook. But
there's no enforcement mechanism for the Endangered Species Act. They will consult, and the blanket take liability applies no matter what the result is of that consultation.
I beg to differ, Your Honor. If plaintiffs, for example, feel that this permit is not doing enough to minimize take or to avoid jeopardy, they can sue in Florida State Court.
I'm sorry, who can sue in Florida State Court?
Plaintiffs, anyone, but can challenge an individual permit in Florida State Court. Florida's permits are subject to judicial review in Florida State Court.
But the default of this program is that you're immune from take liability as long as this process is followed, but the process doesn't ensure that all of the steps that you're supposed to take to get that protection from take liability happens.
I beg to differ. It does ensure that. It absolutely does. It's a detailed process where Fish and Wildlife Service has 3 separate opportunities to comment on permits. Florida has to send permits to Fish and Wildlife Service, applications to Fish and Wildlife Service immediately after it receives them. Fish and Wildlife Service can comment at that time. Fish and Wildlife Service can also comment during the public notice period. And Fish and Wildlife Service can comment through EPA.
Right, so Florida says we disagree with your comments. What happens?
Florida may disagree, but Fish and Wildlife Service's conclusions are determinative. That conclusion.
No, Florida can still issue the permit.
Then it would be in violation of the memoranda of agreement, but more importantly with Florida's regs. Because Florida's regulations specifically say that no permit shall be issued that jeopardizes the continued existence of endangered or threatened species or results in the destruction or adverse modification of habitat, and that compliance with any requirements resulting from technical assistance by the Fish and Wildlife Service shall be determinative for purposes of evaluating violations. And that's Florida Administrative Code 62-331.0533. So
Well,
taking
say
your
Florida- Say Florida just doesn't abide by it, it's a hypothetical, what would happen next? Abide by a comment from the Fish and Wildlife Service.
then Florida would not, a couple of things, Your Honor. Florida would not be in compliance with its own regulations, with its memoranda of agreement, and with the biological opinion. So as to that individual permit, if there's an aggrieved party, they can challenge the permit in Florida State Court under the Florida Administrative Procedure Act and say this permit is
Who would
arbitrary.
challenge that?
Excuse me?
Who would challenge that?
I think an environmental group, a plaintiff who says, you know, I go here, I recreate here, I don't think this is protective enough. The vision is not that Florida's permits will never be subject to suit. Congress envisioned that state permits would be subject to suit, but in state court. So Florida doesn't comply, plaintiffs sue, and they say, look, Florida didn't comply. And that is a plain violation of Florida's regulations, not to mention the biological opinion and the memoranda of agreement. But also, if Florida is not complying, then EPA would have a basis to withdraw the program. Part of what Fish and Wildlife Service relied on in the biological opinion is EPA's ongoing oversight authority over the program.
So Judge Moss felt that this program, which relied on the decision in cooling water, which in turn relied on, I think it was in the 11th Circuit decision, felt that those decisions did not, well, that cooling water was inconsistent with the statute and regulations, and that the 11th Circuit decision didn't really support this program either. This is at, around JA 1349, 50, 51, pages, 66, 69 or so of the opinion. Tell me how the district court was wrong in its analysis of the statute and regulations.
Yes, Your Honor. So the district court erred because the Endangered Species Act says that you have to do a biological opinion. You have to ensure that you'll avoid jeopardy. And that's what Fish and Wildlife Service did here. And the Endangered Species Act says you have to rely on the best available science. And Fish and Wildlife Service said, we can't know, we don't know. So the best available data and science that we can rely on is a process here. And the Endangered Species Act doesn't preclude that. And Fish and Wildlife Service issued a biological opinion. It analyzed, do we think there will be take? And it said, yes. And under the Endangered Species Act, you have to issue an incidental take statement if you think there will be take. Judge Moss said that he didn't think cooling water intake he distinguished it on the basis that it involved a regulation instead of a program approval, as we have here. But we think that was error. First, the services regularly issue biological opinions without engaging in rulemaking, and they act in accordance with those opinions, as do the agencies and applicants subject to them. Second, the record contains ample evidence of binding commitments, including memoranda of agreement, Florida's regulations, as we discussed earlier, and EPA's Clean Water Act oversight authority. We think Judge Moss erred in reading the statute and what it requires, particularly in harmony with the Clean Water Act.
So your friends on the other side say it was impossible for the Fish and Wildlife Service to know what the impacts would be, but apparently there is a sort of a robust history of approvals under the Clean Water Act by the Army Corps of Engineers. And there's plenty of data and information about which species have historically been implicated by some of these acts and the types of actions that have been submitted for approval. So why doesn't that undermine your argument that there was no way of knowing?
For a couple of reasons, Your Honor. First of all, the Fish and Wildlife Service evaluated the data. It looked very carefully at the past 5 years of permitting data from the Army Corps of Engineers. And it said this helps us understand the types of permits we might see and helps us understand whether this process is structured sufficiently to be protective. But Fish and Wildlife Service, this is a one-time approval into perpetuity. And Fish and Wildlife Service said, we can't know forever how many permits might be issued, what types of activities, what the take might be in all the different assumed waters in the entire state of Florida. And frankly, Fish and Wildlife Service also acknowledged we don't know what species might be listed 15 years from now. There could be different species listed. So it needed a process that would work long-term into perpetuity. And Judge Moss said, well, they could look at the core data and say, here's a take limit for one species for a year. But that's not adequate for a number of reasons. First of all, the take is supposed to be incidental to the activity. Under the Endangered Species Act, you say, what is the activity that we think is going to happen? Okay, how do we minimize that take? What is incidental to that specific activity? The Endangered Species Act doesn't say, let's say how many animals we can kill every year before we cause jeopardy, no matter what. You're only supposed to do take incidental to the activity. And so that's what Fish and Wildlife Service was saying. We're going to look at every individual activity.
Right, and I guess the whole purpose of that is you've made a no jeopardy determination. It assumes a certain amount of incidental take. And there's a provision that says, if it turns out your incidental take is higher than what we expected, there's a re-triggering mechanism where you have to consult again. And this incidental take statement doesn't include anything like that, and therefore doesn't fulfill the purpose of the incidental take statement, does it?
It does, Your Honor. You reinitiate consultation. So to your specific
What's
question.
the trigger for reinitiating consultation?
So Fish and Wildlife Service is going to set a limit for every individual permit that will cause take. Some won't, and with some, they'll require measures to prevent any take. But for those that will, Fish and Wildlife will set a limit. And under term and condition 9 of the biological opinion, if that take limit is met, then Florida must reopen the permit and go back to Fish and Wildlife Service.
It's an incidental take limit or a take limit?
It's all the permits here are only allowing incidental take that is incidental to the activity. None of these
So
permits
I guess
allow.
the question is then, I guess normally, wouldn't that be under Section 10 of the Endangered Species Act, that each individual permit would be subject to scrutiny?
I don't think so, Your Honor. I mean, if a federal agency had issued the permit and they said, your take limit is 5 eastern indigo snake, and the federal agency said, oh, we've hit 5, you go back to the Fish and Wildlife Service and you talk to them. And here, what they're saying is.
But I guess what's odd, though, is usually the consultation is with the agency under Section 7. And so it's usually, agency wants to take some kind of step or conduct, and it might affect an endangered species. They have to go through this consultation. And you're trying to take that process, which is about agency action and agency consultation, and you're trying to, it seems, shoehorn that into individual permits and letting individual permits, which usually would be evaluated under Section 10 on a case-by-case basis, but you're trying to get this broad take liability immunity from Section 7 and then shoehorn it or apply it to the individual permits, which should be going through a more extensive process under Section 10.
I disagree, Your Honor. I don't think there is a usual in.
Well, the purpose of Section 7 is for agency action, not individual permittee action, correct?
The purpose of Section 7 is to ensure that agency actions authorized, conducted, or
Right.
carried out.
It applies to agency action.
And EPA was taking an action here.
No, I understand. But then you're taking that sort of process, it's a Section 7 process, which addresses agency action, and you're trying to find blanket take immunity for individual permits down the line, which ordinarily, wouldn't they be subject to Section 10 review, which is much more, I guess, thorough?
A couple responses, Your Honor. First, I beg to differ that Section 10 is more thorough than what we have here. But, and two, only 3 states have assumed 404 permitting authority, so I don't think we have an ordinarily. My understanding from the Fish and Wildlife Service is that none of the New Jersey permits have gone through Section 10, the Section 10 process. And my understanding is that in Michigan,
Did they go through the Section 7 process? The
they,
permit applications in the other 2 states, did they go through a consultation and a Section 7 process? Because my understanding was the government had taken the position that these are not discretionary permits, so they normally wouldn't have gone through Section 7 analysis, except Florida asked them to make it discretionary so that they could go through this process and get this approval.
so there's a couple pieces there, Your Honor, that I want to unpack. First, to the question about New Jersey's program specifically. There's a memoranda of agreement between New Jersey, I think it's the New Jersey Department of Environmental Protection and the Fish and Wildlife Service, and they have agreed to coordinate and try to minimize and prevent any incidental take from the permits.
But
So
when New Jersey applied to take over the permitting process from the Army Corps, was there a consultation under Section 7?
yes, Your Honor, there was a consultation. It
For
was,
the permit application, for the permitting?
yes, Your Honor, it was informal consultation, so there was not an incidental take statement because there are many fewer species listed species in New Jersey than in Florida. It's at JA 2690, but it's the letter from the Fish and Wildlife Service, but basically at JA 2690, which is in Volume 9, New Jersey said, we're relying on this memorandum of
So
agreement.
there was a no jeopardy determination?
Yes, yes. And we're going to implement this memorandum of agreement and to ensure that protective measures happen and take is avoided altogether. But you can't avoid take altogether in
All right.
Florida.
Well, just to make sure I understand you, you're saying that when the state of New Jersey applied to take over the permitting process under Clean Water Act 404 from the Army Corps of Engineers, they submitted an application to do that. And there was a formal consultation or a consultation under Section 7 of the Endangered Species Act, and there was a finding that there would be no jeopardy to species?
Yes, Your Honor. Just a
But
small,
no ITS. I thought you had to have an ITS if there's no jeopardy to species.
you
In
have,
case that changes.
you have to have an incidental take statement if you think there will be take. In New Jersey,
So they thought there'd be no take in New Jersey.
yes, Your Honor. They thought there would be no take in New Jersey. For example, the letter from the regional director of the Fish and Wildlife Service says coordination under the memorandum of agreement is designed to eliminate adverse effects to the listed species and designated critical habitat. It then goes on to say, when this coordination process fails to eliminate take, the applicant must seek authorization under Section 10. So in New Jersey, they anticipated that they would be able to,
And you have to seek authorization under Section 10.
which they have never done. It is my understanding from Fish and Wildlife
But I
Service.
guess the point is that is a protective measure that makes sure the Endangered Species Act will be followed. And there's nothing like that in the Florida plan.
In the Florida plan, there isn't anything like, you have, if you know, so in New Jersey, they said, we don't think there's going to be any take. We're going to avoid it, which you can do in New Jersey. There's just many fewer
But
listed
just in
species.
case, we would go under Section 10 of the Endangered Species Act. The Florida plan, nowhere in the Florida plan does it ever say there's going to be conformance with the regulations that interpret the Endangered Species Act about, what you need in an incidental take statement.
I beg to differ, Your Honor. Florida's memorandum of agreement with Fish and Wildlife Service.
I thought you did agree. You just say it's substituting a process that's adequate. You agree that it's not going to go through all the steps that's required by regulation or statute for a take statement. You say it, I thought your position was they don't need to do that because they couldn't do that because they don't know, and the process is adequate. I thought that was your position.
Our position is that they're relying on a process And that process will include the steps. With each individual permit, the process will include the steps that you would have under Section 7. So, for example, Fish and Wildlife Service said, we're going to do this process. We're going to look at the action area. We're going to look at the effects. We're going to look at cumulative effects. We're going to look at other actions in the area that might affect species. We're going to look at the amount of take. We're going to assess whether that will cause jeopardy. We're going to require mitigation measures to avoid take, and if not, we can't avoid it, minimize it. We're going to look at the status of the species. So the process that Fish and Wildlife Service laid out involves the same analytical rubric that you would have under Section 7. We acknowledge it is not Section 7 because Florida is not a federal agency,
Right.
but it involves the same analytical.
So if these things are not complied with, and there's a state in Florida court, which you indicated was the remedy, the suit in Florida court, would that be about Florida is not complying with the MOU? It wouldn't be actually to vindicate the standards of the Endangered Species Act, correct? Because that's a federal statute, and you're not doing that in Florida court, are you?
I think the suit in Florida court would be you're not complying with your Florida regulations and you're not complying with your Florida laws. Florida's regulations say
But how
that
does that vindicate the interests of the Endangered Species Act?
because the Endangered Species Act is about avoiding jeopardy, Your Honor. And they have a process here to ensure that every single state permit avoids jeopardy. And if there's
And then if it doesn't, you say you can sue in Florida court.
yes,
But what you can sue in Florida court for does not involve vindicating the Endangered Species Act.
well, Florida has adopted the same definitions of threatened and
Fine,
endangered
but it
species
doesn't
and
vindicate
jeopardy.
the Endangered Species Act, so there's no requirement to comply with the Endangered Species Act.
Florida's regulations say that we have to comply with Fish and Wildlife Service's determinations in the technical assistance process. And we cannot issue any permit that jeopardizes the continued existence of endangered
But
or
you
threatened
agree with me,
species.
though, that there's no way to vindicate the actual Endangered Species Act.
I do not agree, Your
In
Honor.
Florida courts can do that?
Because Florida has adopted these regulations and
But
these
it's Florida
standards.
law, it's not the federal law.
Florida law has incorporated the same definitions. And in Florida State Court, you can say you aren't complying with the terms of the biological opinion issued under
Correct,
the
but
Endangered Species
you
Act.
cannot directly vindicate the Endangered Species Act in Florida court in one of these suits that you propose are an adequate remedy.
I'm going to have to disagree, Your Honor. I disagree because a plaintiff could say, you're not complying with the Florida regulations. You're not complying with this process. You're not complying with the biological opinion. And these permits or this permit is causing jeopardy, or it's not doing enough to minimize take. You didn't adopt the Fish and Wildlife Service's protective measures. And let's say that a plaintiff says Florida has done this, I'm so frustrated. They can also petition EPA and say, you need to withdraw Florida's program. So there are avenues for relief.
Can I ask you, am I correct that the record reflects that somewhere between 90 and 98.6% of the Florida's Clean Water Act permits do not involve incidental take?
The majority of them do not. I don't know the specific
I
percentage,
think
Your Honor.
Judge Moss said a large percentage of these permits at issue will have no effect.
Absolutely true. One final point, Your Honor. The United States, we think Florida raises valid points that plaintiffs lack standing, and we would like to join their standing argument, and I'll defer to Florida to present that further.
We'll give you a couple minutes to reply, Mr. Street.
Thank you, Your Honor. May it please the court. I would like to start with some of the questions that have been asked and then circle back to standing because I do think that standing is lacking under Crow Creek and Waterkeeper. But to go directly to some of the questions, first, Judge Wilkins, I think, put his finger on it, that Judge Moss and my friends on the other side are directly and unapologetically asking for a circuit split with Waterkeeper, the only on-point case that addresses this type of programmatic consultation, where it's approval of a federal program that will be carried out by states issuing permits and doing a species-specific analysis at the state permit level. Turning to Judge Pan's questions, I want to start where you, Your Honor, left off with the question about the Florida suit. And we very much agree with Ms. Jaffe that if you look at, for example, Florida Administrative Code 62-331.053, it directly incorporates the very Endangered Species Act standards and says Florida may not issue a permit that could cause jeopardy. That is stripped directly from the Endangered Species Act. Florida cannot issue a permit that fails to incorporate Fish and Wildlife Service or NMFS minimization conditions. That's the exact same thing that happens in the Section 7 process. The Corps consults with the Fish and Wildlife Service. It consults with NMFS. Those agencies give the Corps minimization recommendations, and the Corps, in fact, can either take them or not take them. Florida has to take them. So those ESA substantive standards are hardwired into the Florida regulations, and it's not only in the Florida regulations that are enforceable in Florida court. I would urge the court to take a look at page 2601, which is the biological opinion, and page 2668, which is later in the biological opinion. At 2601, it says Fish and Wildlife Service reviews each permit, quote, to ensure compliance with the Endangered Species Act. So Fish and Wildlife is directly applying ESA standards in its permit-specific analysis.
I guess the issue here is, yes, perhaps some of the steps that Florida would take would be protective of endangered species. But to take a step back, we're talking about a statutory provision in the Endangered Species Act that talks about whether an agency is complying with the Endangered Species Act. And it defines certain steps that need to be taken to make a no jeopardy determination and then an incidental take statement. And it seems, I don't think there's a dispute that these specific steps have not been taken in this case. And what is being argued is that it is reasonable to not take those steps and substitute those steps with a process that would be protective of endangered species. But I'm just having trouble seeing why that's allowed.
Sure. A few points on that, Your Honor. First of all, I think our brief walks through the textual analysis of why what the agencies did here does comply with the strict terms of the statute. And that's for a couple of reasons that the text gives us. The text uses very broad terms like specify the impact on the species, detail the effects on the species, and also very broad terms, and all of those have to be done in light of the best available data there. So it's a very flexible standard.
But isn't it true that in this program, your position is we couldn't do that because we're talking about a bunch of permits in perpetuity. So we don't know what the exact effects are as we sit here today. And the best available data doesn't tell us that. And so we can dispense with those requirements and instead, in the future, we will take care of this.
That is not our argument, Your Honor. And I think our argument is exactly what the Second Circuit said in Cooling Water, which is that the process does specify the impact on species, because our goal, and I think it's important to take a step back as you suggested and look at what the goal of that Section 7 analysis is. It's to determine whether jeopardy will occur as to any particular species. Now, as Your Honor points out, in the ordinary context, that's easy, right? You've got a discrete permit. It might affect one or two species.
A discrete agency action.
A discrete agency.
Section 7.
Yes, a discrete agency action, which could be like a federal pipeline or anything like that. It's in one area. They look at the species. They try to evaluate the effect. They give an incidental take limit. But that's not the only type of action that's covered by Section 7. Okay, Section 7 action is defined in the regulations to also include authorization of a program. So when you are evaluating the effects of a program and you're detailing the impact on species of a program, you are by definition not going to be able to look at the species specific level when it's a program that encompasses an entire state, 200 plus species, scores of different types of permitted activities running from mining to residential construction. So the type of analysis that you do has to mirror the type of action that's being analyzed. I think that's what the Second Circuit said.
But it wouldn't be impossible, for example, to have a program that says, we will approve Florida taking over this permitting process, and any individual permits will be subject to Section 10.
So let's talk about that. I think that was a theme in your Honor's earlier questioning. First of all, the first question that has to be asked is there an agency action? I think everybody agrees there's an agency action when EPA is approving the assumption of Florida's program. So once you get on the Section 7 track, there are certain things that you have to do. One, you have to analyze the effects of the species and determine whether or not there's jeopardy. The agencies found no jeopardy here. But if you find effects, potential adverse effects and incidental take, then you have to issue an incidental take statement. You just simply have to do that. So everybody agrees here that you have to go onto the Section 7 track at the outset. I think where my friends differ is that they want to cut out that incidental take statement and say, no, go ahead and go down the Section 7 track. And Your Honor, I want to point out that I think as Ms. Jaffe mentioned, at the broader level under under the New Jersey program, New Jersey it actually did a consultation. It was just an informal consultation. So there's no dispute that when the agencies are approving an EPA assumption, absolutely has to consult and take into account species. The question is whether you go to the formal consultation because there are going to be effects. Now, I think the point was made about.
But isn't it correct that they could approve New Jersey taking over that permitting system and say that there's no jeopardy because they know that individual permits are going to have to comply with the Endangered Species Act?
Well, I don't think that's why they approved a no effect determination in New Jersey. I think it was, we don't have a lot of record evidence on it, but I think it was because there were.
There's no blanket incidental take liability protection in New Jersey.
Correct. But that's because, again, they did not make a determination that there would be incidental take, right? So let me just back up just for a second. When the Army Corps has been running this program, right, previously, it's been issuing the Section 404 permits. As Judge Henderson alluded to, the record shows that when the Army Corps has been issuing these permits in Florida, 7% of them do involve incidental take. So when Florida is taking over this program, it's not some gerrymandered alternative route. When Florida's taking over the program, it's also going to have incidental take because they're going to be applying the same standards. So because Section 7 requires an incidental take statement, if incidental take is to be anticipated from the federal action, it has to have an incidental take statement. Now, what we did and what we did in collaboration with the agencies is we built in all of those same Endangered Species Act standards, and we built in incidental take limits into the state issued permits. And what the Florida regulations say is that Florida will send these permits to Fish and Wildlife Service, and Fish and Wildlife Service will establish for each permit an incidental take limit. And that is going to be binding on Florida through a suit in Florida State Court. And so it's operating exactly the same as it would if the Corps consulted with Fish and Wildlife, issued the permit, and it has an incidental take statement. The only different incidental take limit. The only difference is it's going to be enforceable in the first instance in Florida State Court instead of in Florida Federal Court. But that's not a bug. That's a feature of the Section 404 program. Congress wanted states to take over the 404 program. And if you have states issuing the permits, inherent, instead of going through Section 7 on a permit by permit basis, inherent in that is that enforcing those standards is going to be done in state court, not in federal court.
I think the bug is that the Section 7 consultation addresses the EPA's approval of this whole program. And the bug is that EPA is approving this program, which includes approving state-by-state permits, or at least making them eligible for the take liability protection. And then you're saying later on down the line, Florida's going to do all these things. That's going to make it okay. But the bug in the system is that Section 7 is supposed to deal with EPA and EPA's conduct in approving this. And EPA isn't complying if it's relying on a process that it can't really control anymore. It's going to go to a state court. It's just no longer part. I mean, I know you're going to say Fish and Wildlife Service is going to be, involved, but the bug in the system is this is a process that's supposed to address agency action. And all of the action is happening at the state level with individual permittees. And it's just not, it doesn't seem to me that this process is designed to address state-by-state permit take statements, et cetera. Like that's just not what's contemplated by an overarching statutory structure and scheme that's supposed to protect endangered species at the federal level.
Your Honor, I don't think anyone disputes that states can take over permitting that would otherwise be done under Section 7. That means it
Absolutely.
has to be outside of Section
Absolutely.
7,
And
right?
there have to be compliance with the ESA
Yes.
independently,
Right.
without having it all in one program.
Right, and that was exactly the same as in cooling water, where you had the states having to issue the 402 permits. And these very same plaintiffs were there in front of the Second Circuit and made that exact same argument. And the Second Circuit said, well, when the states take over permitting, of course it's outside of Section 7. So we look at the process and make sure that the technical assistance process is mandatory and hardwired into the biological opinion, that it was the basis for approving that state program in that case, and that it would be enforceable. And because you have to have these permits issued by the states, that's ultimately the question.
Is there protection, like I guess prospective protection from take liability in the cooling water instance?
Yes, it's exactly the same. In fact, this was quite self-consciously modeled on the cooling water biological opinion and the incidental take statement, because that was.
Was that case though about a different section of the Clean Water Act? That's my recollection.
Yes, it was about the regulation of cooling water intake structures and the parameters of what those had to have in them and how protective they had to be. And then the states would issue the permits and do the permit by permit species analysis with the permit by permit take limits in those. So it's really, yes, it's a different statute. It's a different program, but it's the same idea of a federal authorization that will be carried out through state permitting. In fact, not just any state permitting, but permitting under 402, which is of course the sister provision of 404. And I think Judge Pan, your question was getting at, well, in Section 10, isn't that the right way to go? And I think if you think about what that means, then it would be a massive disincentive for states to ever go through the 404 assumption process, because they wouldn't be able to offer the same incidental take protection that the federal government would be able to through the Section 7.
I don't think the 404 permitting process is intended to address the Endangered Species Act.
Oh, Your Honor, I would strongly disagree with that. I would look at 40 CFR 233.23A.
But I mean the permitting, like taking it over. I mean, it just seems like an underlying assumption, correct me if I'm wrong, that you're making is that 404 is a way for us to more efficiently comply with the Endangered Species Act for all of these permits. Of course, all the permits have to comply with Endangered Species Act, but isn't the default that we have two independent statutes here, the Clean Water Act and the Endangered Species Act? You got to comply with both of them.
No.
But you're trying to do something to make it more efficient. We're going to make one program that deals with all of this in one program.
No, Your Honor, I disagree with that. And I don't hear my friends on the other side to disagree with the concept that a Section 404 assumption requires EPA to consider whether the state assumption program will comply with the Endangered Species Act.
Then why is it, maybe you're not the right person to ask, why is it that previous to this proceeding, the government considered the 404 permitting a non-discretionary act, which wouldn't be subject to any of this, Section 7 consult?
Right. So non-discretionary is a slightly misleading term in this context. I think the court should look at the home builders case, of course, which talked about this. and found that Section 402 did not require consultation with Fish and Wildlife Service. And the reason there is because Congress gave 9 requirements that states have to meet in order to comply with Section 402 and take over the permitting of point source discharges. And Congress said, the court and home builders said, we can't add on a 10th, which is consulting regarding species. But under Section 404, a state cannot assume control of Section 404 permitting unless it shows that it has a program that can comply with the Section 404 B1 guidelines. In other words, it has to show that it can do the same thing that the Corps does when it comes to protecting species. And I believe 40 CFR 233.23A spells that out most expressly. It says the states have to show that they're able to ensure compliance. And if you look at, for example, the withdrawal of assumption authority that EPA can do, one reason is that they're failing to protect species. The states are failing to protect species. So if I could, then I would turn to standing briefly. And I think Crow Creek and Waterkeeper are the key cases here, and they stand for the proposition that when the federal government authorizes the states to run a program under federal standards, federal law standards, or under ongoing federal oversight, it's going to be extremely difficult for a plaintiff to ever show standing. And that's exactly what we have here. As I detailed earlier, the ESA standards continue to apply through the Florida consultation with the Fish and Wildlife Service. And so for the plaintiff's interests to ever be injured, and of course their interests are viewing species and studying species, they would have to show that incidental take would be more likely to occur under Florida's program, substantially more likely, it's the test for procedural injury, substantially more likely to
Assume that they're correct for purposes of standing, and they're saying that your program is less protective of species. So there'll be few of them. That affects our interests.
So 2 answers to that, Your Honor. I think that their merits analysis that the court has to assume for purposes of standing is exactly what Judge Moss found. He did not find, his basis for rejecting the biological opinion was not that the Florida technical assistance process was less protective. His basis was that the biological opinion needed to be more detailed with respect to species, species-specific analysis, projecting it decades into the future, that there needed to be take limits in the biological opinion itself, and that the technical assistance process itself was just not a lawful way to satisfy Section 7. The merits of the case are not about whether the technical assistance process is good or bad or equal to Florida law. And even if that were part of their merits case, I think Crow Creek answers this because the plaintiffs there made the exact same argument. They said the federal government is just not going to be able to enforce the law as much. Federal law will not apply with the same force on those transferred lands. And the court just said that's not what the statute says. So to the extent the court thinks it has to look at it, I've given all of the citations that say this program complies with the substantive standards of the ESA and the Clean Water Act. And not only that, not only those substantive standards continue to apply, but you have 2 federal actors ensuring that they continue to apply. Every permit goes to Fish and Wildlife Service to ensure no jeopardy and to give minimization measures. And even if Fish and Wildlife Service were to somehow drop the ball, even if Florida were to drop the ball on its own duty to comply with the Fish and Wildlife Service recommendations and to ensure no jeopardy, we haven't really talked about EPA. But EPA has an independent statutory and regulatory duty to review these permits and object to them if they would cause jeopardy, if there's a risk of them causing jeopardy. And if they object, Florida cannot issue those permits. Those permits have to go to, Florida has to either resolve EPA's objections or those permits will get transferred right back to the Corps and will go back to the old Section 7 process for that permit. Even if all of those processes broke down, the permit will not issue until a Florida administrative challenge is heard. So plaintiffs would have the opportunity to go into court, point to that federal Florida regulation that I quoted, and say to the Florida court, this permit will cause jeopardy. It does not include the Fish and Wildlife Service minimization measures. they would have a lock cinch case that that permit would violate Florida law, and that permit would never take effect, and you would never have the increased take that the plaintiffs are worried about. And not only that, they can build their own administrative record in the Florida proceeding. They can build the record. It's not limited to what was before the permitting agency. So I think when you walk through all of those steps of contingencies that would have to break down before you would ever have a permit issued, it is hugely speculative. And so I think we're in the same position where we were in Crow Creek, where this is really, there's no standing to challenge the approval of the program. And in Waterkeeper as well, which of course was a state coal ash permitting program. And the court said it's speculative to think that that a coal ash permit will ever be issued in a, quote, less environmentally friendly way than it would have under the federal system. That's the standard. It's totally speculative here as well. So the remedy, we've talked a little about what's the remedy if the process breaks down. Number one, EPA can federalize the permit. Number two, you go into state court and enforce these same federal law standards. Number three, my friends could petition the EPA to withdraw the assumption of the program. It's not working like it was supposed to work. It's not protecting species. And that would be reviewable in this court as well. And finally, I would say at page 72, Waterkeeper suggests that there would also be a Federal Endangered Species Act citizen suit against any actor who does not comply with the regulations issued pursuant to this program. So I think there is that backstop as well of getting into federal court. I don't want to wear out my welcome, but if there are any further questions.
Thank you. We'll give you a couple of minutes in reply.
Thank you.
Ms. Riker.
Thank you, Your Honors. May it please the court. Christina Reichert on behalf of the Environmental Appellees. I would like to start by addressing a few points that were raised during questioning of the other side, and then move into our affirmative case regarding this illegal action.
Why don't you start with standing, please?
Yes, Your Honor. Standing here for plaintiffs was clearly established and found by Judge Moss. None of the factual findings that underlie that standing have been challenged by the other side. And in reality, what happened here is that EPA approved a program that was fundamentally less protective of endangered species. And as long as that program operated as it was designed and approved, our members' aesthetic and recreational interests would be harmed. And although we were not required to do so, we even included in our declarations particular permits that were originally before the Army Corps of Engineers and then were transferred to the state of Florida after approval that would harm those interests, in particular for the Florida panther and other listed species.
And you're saying that factual findings that were made in the district court counter what your friend on the other side is made as far as the significance of the Crow Creek and Waterkeeper decision?
Yes, Your Honor. One of the things that Judge Moss found in his analysis of standing is that the technical assistance process is woefully less protective than the Endangered Species Act because it does not, in fact, contain the particular requirements that were omitted at the programmatic level. For example, there is no requirement to analyze baseline status of species. There's no requirement for Fish and Wildlife Service to analyze the effects of individual permits. Fish and Wildlife Service is not required to actually create incidental take limits, only to quantify take. And there is no requirement, even if all of those things happen and there is a permit condition that creates a take limit, permittees are covered under the ITS because there's no terms and conditions that govern their behavior. And under 16 USC 1536-0, that activity would still be authorized and covered under this incidental take exemption. And so as long as that program operates as it was designed, without any intervening speculative activity, these harms will occur.
How did the declarations you just mentioned concretely illustrate this?
So for the declarations, At JA 315 to 318, for the Conservancy of Southwest Florida, identified a permit known as Belmar, which was originally going through a Section 10 permitting process in Florida for an Army Corps permit, was transferred to the state of Florida, and those developers abandoned Section 10 in lieu of the technical assistance process because it was easier for them to go through. And so our declarant identified her interests in panthers that regulate this area, and the harm that would occur as this development went forward was the destruction of not only primary panther habitat, which is the most essential to their survival and recovery, but likely incidental take of panthers through getting hit by cars because of the increased traffic that would come along with this development. This project was essentially building a new town in Southwest Florida, and so the size and scope of that activity would lead to incidental take of panthers. There's also additional examples that I can point to at J303.
I'm sorry, so is the idea that there would be incidental take and under the Florida program, they would have, I guess, protection from liability, whereas if they'd gone through Section 10, they wouldn't until they'd gone through the whole thing?
Yes, Your Honor.
I see.
And also, there was likely more take that would occur, more harm that would occur under the state program because they wouldn't have to go through the protective process that the Endangered Species Act creates, which likely would lead to a more protective permit, setting aside additional areas that could not be developed, creating incidental take limits, creating traffic overpasses to prevent panthers from being struck by vehicles, and those kinds of things that happen when the Corps is engaging in Section 7 consultation.
I see. Thank you.
Turning to the merits, I want to start by just laying the groundwork on some of the discussion that was occurring about Section 7 versus Section 10. First of all, Section 7 consultation doesn't occur for every federal agency action. It's only when that action is discretionary. And we agree that EPA's approval is a discretionary action for a 404 program. However,
So why do you agree on that? Because for a long time, they had a longstanding policy that it wasn't. And it seems like they asked for it to be deemed discretionary in order to approve this program.
yes, Your Honor. Originally, so for example, in New Jersey, they did engage in Section 7 consultation. After home builders came out, EPA changed its position and said that it was no longer considering 404 approvals discretionary actions, and so it wouldn't engage in consultation. And the reason that that is, I think, true based on the home builders' decision is in the 404 program, there is a requirement to ensure that no permit would jeopardize species. Not that they comply with the Endangered Species Act, but they have to ensure that any state permit would not jeopardize listed species, and that's not present in the 402 program. As far as whether formal consultation must occur, and that is where there is actually a jeopardy determination, that is where an incidental take statement is created, that is where a biological opinion is created. That only happens if Fish and Wildlife Service concludes that the federal agency action is likely to adversely affect listed species. When New Jersey was going through its process, EPA initially concluded that there was not likely to be an adverse effect to listed species. Fish and Wildlife Service disagreed, and they went through a process to create the protections that are in place in the MOU for New Jersey. Those protections include Fish and Wildlife Service has to make effects determinations. They have to make jeopardy determinations. If a permit is likely to adversely affect species, EPA has to object to that permit. And if the state is not able to overcome that objection, the permit is then sent to the Army Corps of Engineers for processing, which means that it engages in Section 7 consultation. And if there is any dispute between the state and EPA on jeopardy or take, EPA must object to that permit as well. If it is not resolved by the state, it must go to the Army Corps of Engineers. And it's also true that Fish and Wildlife Service said that any incidental take that would occur in the New Jersey process must be addressed by either Section 7, if it's issued by the Army Corps of Engineers, or through Section 10, if it is issued by the state of New Jersey. And so because those protections were in place, Fish and Wildlife Service concluded there was not likely to be adverse effects. They did not need to issue a biological opinion. They did not need to issue an incidental take statement at the programmatic level. And one thing I will note is that in Florida's request for a limited stay before the district court, they stated that they could apply a New Jersey-style program in Florida. Second, on to what happened here. So they determined that EPA's action was likely to adversely affect listed species. However, they did not do any of the analyses that are required to underlie a no jeopardy decision. The regulations are very clear that Fish and Wildlife Service must analyze the baseline status of species, add the effects of the federal agency action to that baseline to determine if there is jeopardy. They did not do that here. In addition, Fish and Wildlife Service must first determine that it is reasonably certain that incidental take is likely to occur. Not that they think that incidental take is going to occur, but that it's reasonably certain before they can issue an ITS. Here they said they did not have sufficient data to know what would happen under the state program, but they still had to have concluded that it was reasonably certain that take would occur. Then they decided to issue a broad incidental take statement that authorized an unlimited amount of take for the state program as long as it lived. Congress never intended the Endangered Species Act to operate as this kind of a blank check. Second, the Endangered Species Act is designed to accommodate and address the exact uncertainty that occurs in most programmatic consultations. It requires the wildlife agencies to do an initial analysis based on the best information that they have and not the best possible data that could exist. And so they did not need to know all of the impacts that could possibly occur for the life of this program in order to do this analysis. They just had to do the best they could. And based on that analysis, there would be also a requirement for them to reinitiate consultation if new information comes to light 10, 15, 20 years down the road that shows that this analysis is no longer accurate. For example, right now, development pressure is very concentrated in Southwest Florida. That's the last remaining home of the Florida panther. And so right now, if they did this analysis based on the historical data, they could show that, okay, in Southwest Florida, we know that panthers are going to be impacted. We know there's only 230 of them left. And we know that this is their last remaining occupied habitat. We can take that information and say, historically, these permits show that on average, 3 panthers are taken a year. That seems like a reasonable amount of take that we can create a take limit for. Or we know that annually, 30,000 acres of this habitat are destroyed. Let's think about what that would mean if that continued for 20 years down the future. They didn't do that analysis here, and so there's no actual protection for the panther under the state program. And it allows the kind of piecemeal destruction of our habitat that the ESA was designed to prevent.
And so they say that they're going to have incidental take limits in each permit. And I guess, doesn't that end up with a higher aggregate amount of incidental take? Because of each permit, they have to allow somebody to have some incidental take. The numbers are going to add up higher, aren't they?
Yes, Your Honor. And first, I will say that the technical assistance process does not require them to create permit level incidental take limits. It does only require Fish and Wildlife Service to quantify for an individual permit, which they have done. It doesn't require that to be a binding limit on the permittee. On the second point, this is exactly the situation that the district court in DC dealt with in Brownlee, which addressed the Army Corps' decision to issue a nationwide permit in Florida that affected the panther, but they failed to do a programmatic consultation. And the court recognized that a comprehensive programmatic consultation is necessary to avoid this kind of a piecemeal destruction, this death by 1,000 cuts for the panther. Another point I'd like to turn to now is about the technical assistance process itself. Because in reality, when you look at the language of the technical assistance process, it doesn't include the things that they failed to do at the programmatic level. As I said, there's no baseline analysis. There's no requirement to use the best available science. There's no requirement for them to do an effects analysis. And so even if it is binding on Fish and Wildlife Service, it doesn't actually stand in for adequate programmatic consultation. And so that means that consultation did not occur at the programmatic level, and it would not occur at the site-specific level. And finally, I'd like to address cooling water. So first of all, as you asked Judge Wilkinson, we agree that cooling water was wrongly decided, but we don't think the court needs to reach that issue. It was also decided under fundamentally different factual circumstances. It was not about the approval of a state wetlands or a state Clean Water Act program. It was about EPA promulgating a rule intended to protect fish species from harm that occurs at 402 discharge points. Second of all, they didn't have data in that context like they do here. Those programs had long been assumed by the states, and so there was not Section 7 consultation happening at the permit level like there is in Florida. Also, the state programs do not have a requirement to consider species, as we said, in the 402 program like they do in 404. So the states were not collecting this data. So there was actually a vacuum of information that was present in cooling water that is not present here. And third, clearly in that situation, the technical assistance process was part of the preamble and the regulation that EPA issued. And that meant that, number one, it was appropriately considered by Fish and Wildlife Service as part of its jeopardy determination because it was part of the underlying program. And it meant that it was appropriate because it was enforceable under the Endangered Species Act itself. Neither of those things are true here. And so we do think that you can distinguish cooling water without having to reach this question of whether to create a circuit split.
All right, thank you.
Thank you. We ask that you affirm.
All right, Ms. Jaffe, why don't you take 2 minutes?
Thank you, Your Honor. Just a few points. First of all, the technical assistance process will look at the same types of information that you examine in the Section 7 consultation process, such as the project area, the effects, cumulative effects. That is outlined at JA 2621 to 26, JA 2621 to JA 2626. Two, the technical assistance process will quantify take if there will be any incidental take with individual permits. That's outlined at JA 2670 to 71. Any permit that causes incidental take will be reopened if the take limit is exceeded. That's at JA 2673. Permittees are only covered if they comply with permit conditions. That's outlined at JA 2671. If they modify their project in some way, they are not covered for any additional take. That's at JA 2624. Finally, I want to note one question that Judge Pan had that I didn't answer when I was up before, is that there are circumstances where reinitiation of consultation would occur. For example, if Florida wanted to modify its program, it needs EPA approval for that. And if the modification would affect species in some way, then Florida would have to ask EPA's approval, and EPA would have to go back to Fish and Wildlife Service. And finally, I just want to say that Fish and Wildlife Service relied on a robust process that satisfies the Endangered Species Act requirements and has been upheld by the Second Circuit. This court should uphold that process here and reverse the district court.
Thank you.
Thank you, Your Honor. I would like to note on cooling water that Judge Moss only found one distinction there. Otherwise, he openly admitted he just disagreed with cooling water. And the distinction that he relied on is that in cooling water, the technical assistance process was part of a federal regulation. But if you look at cooling water, the reason it found that the technical assistance process was binding and enforceable is because it was the basis of the agency action. And because counsel said in open court that it was the federal government and the state considered it binding on them. Both of those things are true here. The EPA and Fish and Wildlife Service only approved Florida's program because this technical assistance process was hardwired into it and was the way to avoid jeopardy and to minimize incidental take. And second, you've had the government counsel here, government counsel in district court quite clearly said, we consider this binding. We are going to apply federal standards. We will not let a Florida permit issue that violates it. So I think that you would have a circuit split. And again, you can read cooling water, and almost every single argument was made by the same plaintiffs and rejected, including deference to the scientific determination that it was impossible to quantify take on a program-wide level. Turning back to standing for a minute, I think my friend talked about the merits of their claim that Judge Moss found that the technical assistance process was less protective. He was not finding it less protective as a substantive matter. He did not find that Florida and the Fish and Wildlife Service would not enforce federal standards or that they were not binding. He just found that it did not have the things that a Section 7 formal consultation would require, like each permit does not have a baseline effect analysis on the species. So I think that's number one. Number two is even if you do think you have to consider whether something is a merits argument, I would urge the court to look at Section 916 through 918 of Crow Creek. The plaintiffs there said, our merits argument is that under the federal statute, these federal cultural protection statutes will no longer continue to apply. And this court said that the tribe's claim that federal enforcement will diminish is purely speculative. Quote, when the quote statute provides that the secretary will have an ongoing and undiluted role on the transferred land. So the court looked at a merits argument, it didn't let them have the law that they wanted to have when the binding documents said otherwise. If I could just correct one missed site in our brief that's material. My friends have also alleged a failure to consult with the National Marine Fisheries Service. And on page 53 of our reply brief, we cited the page where the agencies did clearly consider indirect effects to downstream species and found that there would not be any effects even in the waters that the Corps retained. We mistakenly cited that to JA 2156, but that quote is to JA 2159. And finally, on the Section 10 point, Your Honor, Section 10 is a voluntary option and it's a rarely used option. The comparison for purposes of standing should not be what protections would have happened under Section 10, because that's not the status quo ante. The status quo ante was the Army Corps of Engineers issuing permits under Section 7, which we know do result in some level of incidental take. The only change here is that Florida is now going to be issuing the permits after doing the same consultation under the same standards. That should be the comparison for purposes of standing. Thank you.
Case number 24-5262. Jazz Pharmaceuticals, Inc. appellants versus Robert F. Kennedy Jr., Secretary of the Department of Health and Human Services, et al. Mr. Akua for the appellants, Mr. Springer for the defendant appellees, Mr. Jerry for the intervener appellees.
Let's wait till the courtroom clears. Let's wait till the courtroom clears.
Sorry.
All right. Mr. Akua, go ahead. Morning.
Thank you. Thank you, Judge Henderson. May it please the court. Kwaku Akoa for Jazz Pharmaceuticals. The Orphan Drug Act seeks to encourage businesses to invest in developing treatments for some 7,000 rare diseases, many very serious, that collectively afflict about 30 million Americans. FDA's rare disease website states that there are no drug treatments for most of those rare diseases, and one prominent advocacy group pegs the share at 90%. Now, the Act chiefly takes aim at that problem by creating a period of marketing exclusivity for companies that win approval for an innovative rare disease treatment, a 7-year period during which FDA, quote, may not approve certain other new drug applications. And of course, the parties' dispute is which of those new drug applications is barred. Now, we think it's not just the scope of the prohibition, but really the nature of it that's at issue here. We say that the ordinary meaning of the statute's text and grammar resolve that question, and they do so in a way that makes the prohibition fixed and predictable, and thus well-suited to spur business investment because it's pegged to the designation decision that FDA makes before the drug maker even submits the application for approval. It so ties the agency's hands by temporarily barring it from approving another application that would use the same designated drug to treat the same rare disease, and that comes straight from subsection A of the statute, which provides that if FDA approves an application, quote, for a drug designated under section 360B of this title for a rare disease or condition, unquote, then for a period of 7 years, FDA may not approve another application, here's the second quoted phrase, for the same drug, for the same disease or condition. And in those parallel phrases, for the same drug refers back to the antecedent for a drug designated under section 360B. And so the same drug, the thing the agency is temporarily barred from approving, is the drug previously designated for the approved application. And Congress's directive is just that simple. Now, my friends on the other side offer, Judge Wilkins.
Yeah, I'd like to interrupt. I want to kind of get down to the brass tacks.
Sure.
What do you think the impact of the 2017 amendment is? What do you think it does? It has to do something. So what do you think it does?
So the 2017 amendments, we think, and the text reflects this, are focused on the DPAMED issue. So when there's already been one approval for a drug, for a designated drug to treat a particular disease or condition, can there be, in what circumstances can there be a second or successive 7-year period of marketing exclusivity? That's what the 7-year, that's what the 2017 amendments are all about.
Okay.
Now,
So if that's the case, I want you to tell me where in the designation section, that's 21 USC section 360BE, there is anything in that statute that says that in order for a drug to be designated, not approved, but designated, that it has to have some sort of clinical superiority. Where does that appear in the statute in 360BB for designation?
sorry, for designation purposes, where in the statute does it say there must be a demonstration of clinical?
Yeah, let me ask it this way. The statute for designation of drugs for rare diseases or conditions basically says that if the FDA finds that this is a rare disease or condition that is to be treated by this drug that the sponsor is seeking to have designated, if they find that it is indeed a rare disease or condition, and that if approved, this will treat that rare disease or condition, they shall approve the designation.
That's right.
There's nothing in there that says that it also has to be clinically superior if it's the same drug. None of that language is in the designation provision, right?
So the designation provision does include a requirement that the follow-on drug demonstrate a plausible hypothesis of clinical.
That's in the 2017 amendment, right?
Yes.
In the 2017 amendment amends 360 CC. The approval, it doesn't amend 360 BB designation.
I think I'm losing the thrust of Your Honor's question.
Let me
And that-
just make it plain to you.
Sure.
We're not playing poker here, but I want you to understand what my concern is.
Sure.
Because it's why right now I'm inclined to say that I think that you lose. So let me lay it out and then you can respond.
Sure.
So the FDA, prior to 2017, had a regulation, which is at 21 CFR 316.25. It says that you can't get designation for the same drug as one that's been previously designated and approved for treatment of a rare disease or condition unless it's clinically superior. As best as I can tell, prior to 2017, there was nothing in the statute that allowed the FDA to place that limitation on designation.
I understand.
So if you follow the logic of DepoMed and Eagle Pharmaceuticals, that regulation would be ultra vires.
I think
Right. But it appears that with the 2017 amendment, by what you say, the work that it does, the FDA has appeared to have blessed this way that designation works under the prior regulatory scheme by saying that, well, you can have an additional condition on whether something can be designated if in restriction, let's say, on whether something can be designated. If a prior drug had been designated and approved, which is otherwise the same drug. So if Congress was approving or sanctioning or incorporating or ratifying, whatever word we want to use, that aspect of the pre-2017 regulatory scheme, then why should we conclude that they weren't also approving or ratifying the other aspect at the approval stage of what the FDA was doing prior to 2017 with respect to exclusivity? Did I make myself clear?
You did, Your Honor, and let me see if I can answer. I think that the text helps us tremendously, and that also the statutory history helps us tremendously. And so on the text, what you have is Congress picking up this idea that FDA had, that there ought to be limits on what they called serial exclusivity. So there's already been a drug for a same drug for the same disease or condition that's been approved. In what circumstances does it make sense to give the next drug also a period of exclusivity? And essentially what subsection C, D, and E reflect are Congress grappling with that question and saying it's got to be new innovation, so a clinically superior drug. Now, Your Honor's question is, well, why wouldn't they have also done that in subsection A? One answer is you don't see in subsection A anything like the reticulated description of how clinical superiority should operate at the approval stage, the marketing exclusivity stage, to allow FDA to say, well, actually 7 years, we're gonna break into it. You don't see the words clinical superiority there. You don't see them say, we have 2 exceptions in B, let's add a 3rd exception. And so you just don't have a mirror image of the careful attention they paid to serial exclusivity, paid to the other question, and everyone agrees that FDA had this idea as well that they could break through existing unexpired periods of exclusivity, but you don't see that reflected in the 2017 amendment at all. You also don't see that coming to statutory history in the discussion of what Congress was doing. And I want to grant that that was what we have is very limited, but let me take you through what I think is telling. I read DeepAmed to announce 3 criticisms of FDA's approach. One, that they issued regulations for 360cc without statutory authority. And that was subsections A and B that existed at the time. And one distinction, Judge Wilkins, to 360BB, the prior statute, is that statute has and has long had express authority for FDA to promulgate regulations. And so it's indicative of policymaking at that in that part of the statute.
So
So-
I guess the bottom line though is Congress chose to use the term same drug, which has a definition in the regulations. And also it seems that it was a longstanding policy to treat such drug as same drug. And it also seems that Congress must have been aware of the same drug definition, but you're trying to tell us that Congress didn't mean to incorporate the same meaning of same drug that's defined by the regulation.
That's right, because I don't think the text takes you there at all. Because, I mean, the Supreme Court has said in Yellen versus Confederated Tribes, linguistic similarity is not enough. When this court has looked at ratification, take Judge Henderson's decision in Genus, it said express approval is what the court looks to. New York versus EPA, the court said when Congress doesn't expressly cross-reference an existing regulation, that cuts sharply against the inference of ratification. That read back to a case called Continental Airlines, where Congress had used commuter airlines, same phrase that the agency had used, the Civilian Aeronautics Board. And this court said the mere overlap isn't enough. So this court's always looked to more when an agency says there's ratification. And then come back to the DeepAmed history, Judge Jackson called out this issue, right? She said that the logic of the statute is that the grant of the 7-year period precludes subsequent approvals for what she called new and better drugs. So that's right there. And then she calls out as well the serial exclusivity limitation and says FDA didn't have authority to do that. Well, the way I read the 2017 statute is Congress only addressed the third of those points. It didn't provide any rule writing authority for subsections A and B, which were what Judge Jackson had in front of her. It didn't address whether FDA could rely on clinical superiority to make a breakthrough determination. It's nowhere in subsection A. It didn't add subsections. And then it turned to subsection D and it said, we're going to put some limits on how FDA uses its old regulations, right? So there's a permanent grant of authority, write regulations for the implementation of subsection C, serial exclusivity, not our breakthrough unexpired approval context. It says, then you can use those, the definitions in the
When we
old.
look at the context though, I guess this comes back to Judge Wilkins's first question. Congress specifically put the word same drug.
Right. And so
we're like, well, what did they mean to do by that? And it seems that the most likely answer is that they were using the definition of same drug that's in the regulation and intended to make it clear that such drug means same drug. That just seems like it would be very confusing for them to use the word same drug and not mean what everybody has understood same drug to mean in this context.
And the proof that they didn't mean to use the same drug in the way that FDA had is in subsection C1. So at the end of subsection C1, Congress talks about this very relationship between clinical superiority and the same drug. And it says that you have to get the serial exclusivity, you have to show that the follow-on drug is clinically superior to any approved or licensed drug that is the same drug. That is, Congress is thinking about those two drugs as being the same, and nonetheless, one is entitled to a period of serial exclusivity. That's how they were contemplating the same drug. And I think that's because they're contemplating it in the same textual terms that you see in subsection A. It can't possibly mean the same drug unless the second one is superior to the first at the end of subsection C. And so Judge Maida's answer to that was, you're right. The same drug definition can't possibly plug in there, but that just means that the same drug means something different there than it means elsewhere. And that should really set your alarm bells off, because in the ordinary course, in two closely related provisions of a statute, Congress is going to use a term in the same way. And if it's a ratifying, right, what we have is the similarity between how FDA, those three words, the same drug, in the regulation and the statute.
Let me
So,
ask you,
yeah.
let me ask you this. So in the exclusive approval statute, 360 CC subsection A,
Yes.
if the drug has been previously designated under 360 BB,
Yes.
and then it is subsequently approved under section 355,
Yes.
is there authority for the FDA to approve it, but to not grant it exclusive approval if it has been designated under 360 BB?
The limit comes from subsection C. So if under subsection C, the sponsor is seeking an exclusive approval for a drug that is a drug that's the same and for the same rare disease condition as the already approved drug, then the secretary may not grant the exclusive approval under A unless the clinical superiority requirement is met. So that's
So prior to 2017, the 2017 amendments, did the FDA have the authority to grant non-exclusive approval when it approved a drug under section 355 that had been designated previously under 360 BB?
no. So Deepamed and Eagle said, this is simple. If designated and approved, then exclusivity follows. And it rejected FDA's understanding, interpretation that there was a clinical superiority limitation. And then, of course, Congress, between Deepamed and Eagle, steps in and says, subsection C, here's the limit. You can, in fact, do what FDA had in mind before. But I think the important point is that for our purposes, when they grabbed onto this issue, they said, let's talk about it. Here's subsection C, here's D, here's E. Let's talk about it in our terms. And they used the same drug. Again, this is one of our most powerful textual points. They use the same drug in a way that can't possibly have the meaning that FDA had ascribed to it in regulation. The other key here in terms of context is
the definition of clinical superiority that they
yes.
is maybe not be completely verbatim, but it's pretty much taken from the FDA's regulation.
Yes,
right?
yes, absolutely. And actually, I think that cuts our way, because if they were using the same drug in the way that FDA had used it, clinical superiority in this definition would just flow right with it. Instead, they're using the same drug in a way that requires a separate definition of what clinical superiority is, because they don't think it comes from the same drug. They think they have to say it.
But it
And-
sounds like your argument is that subsection C is confusing. That doesn't mean subsection A is confusing.
I don't think subsection C is confusing. I think subsection C makes no sense if you read it the way that they want to read it. You can't plug the same drug in to subsection C. But if you read subsection C just as it is with in ordinary language frame, and you say, oh, subsection C is where Congress did the thing that Judge Jackson said in DeepMed they couldn't do. It can limit the grant of serial exclusivity. Subsection C1 says what that limit is. C2 provides an operational definition. D tells you how the regulations can be used.
And it
E
just
tells
seems
you what you
like-
can publish.
It just seems like because subsection C wasn't drafted very clearly, you're trying to say subsection A must mean a particular meaning.
Not
But
at
I
all.
don't know that that's necessarily
Not at
true
all,
where
Your
we
Honor.
have a regulatory definition of, so in
Could-
your
if-
framework, what do we do with this regulatory definition of what same drug means?
I don't think there's a role for the regulatory definition of same drug.
Oh, really?
In-
So
in-
we're going to write that out of
In-
the statutory structure?
In subsection A, because subsection A tells you what the same,
Well, anywhere, I think you're saying subsection C and subsection A have to be read a certain way. I'm asking you, what is the role for the definition under 316.314? There's a definition of what same drug means. What's the role for that?
so I don't,
In your interpretation?
correct, so I don't think it has a role in 360.
Does it have a role anywhere?
CC. I think it may well have a role elsewhere in the statute. My argument is focused on what,
I understand that, but for your argument to make sense, it has to make sense in the entire statutory scheme. doesn't
I
it?
don't think so, Your Honor. And here's what subsection D, which I alluded to, is Congress saying you can't, to the extent the definitions that FDA used to use are inconsistent with the terms of this section as amended by this act, you can't use them.
I thought it says you may apply definitions set forth by
To,
a
to,
state.
to the extent such definitions are not inconsistent. If they're inconsistent,
Okay,
the subsection D says
Okay.
they fall away.
I think my bottom line, the question I'm trying to ask
Yeah.
you is, your interpretation is less likely to be correct if you're trying to tell us that Congress sub silentio decided to excise the definition of same drug from this statutory scheme.
wait,
And I'm trying to understand, like, what is the role for this definition under your interpretation?
the regulatory definition didn't define same drug in the statute. The statute didn't say same drug when FDA wrote the regulations. So
Correct.
same drug comes into.
Which is why it seems like a logical interpretation of what Congress did was they understood that the FDA has been using such drug to mean the regulatory definition of same drug. So we're going to put that in and make it clear that same drug is what they've been doing all along. And you're trying to say, no, they've decided to require a completely different approach, but using the same words that the
And I,
FDA has
and I,
been using all along.
I grant there is that overlap of language, you know, gives a rise to, well, why aren't they borrowing it? But the question then, but then the analysis, Yellen tells us, Johnson tells us, Genus tells us, is does it
I
fit?
understand that you can construct an argument for this, but why is that the best reading of this, given the statutory context?
Yes,
And Congress being aware, we have to assume that Congress was aware of the statutory context, and they chose to put in the words that everybody understands what the meaning of the word same drug means, and that's the meaning that the agency has been applying for all this time. It just seems like the more logical interpretation is they were trying to make it official, what the agency has been doing all along, as opposed to upend what the agency has been doing all along, while using the same words and definition that the agency's been using all along.
I understand that, Judge Pan. If you plug the same drug into a,
I
and
understand the analysis, but why is that a better way of reading it than what I just said?
there's no case that I've ever seen, none my friends cite, in which a ratification definition flips the valence of a statute. So subsection A is all about a prohibition. Thou shalt not. In their terms, the same drug creates a giant grant of discretion to the agency to decide to approve drugs, notwithstanding may not approve. I've never seen a statute do that. I've never seen a case describe a statute as doing that. It would fundamentally flip around the policy of the act. And the one thing we have from the legislative
I
history.
can't think of a statute off the top of my head, but there are often terms that have meanings that are beyond the plain meaning on the page. There are lots of statutory
But
contexts and structures where a meaning is taken on from other parts or the context, and here, that's what we have.
But I don't think that's the context. I mean, the context is Congress saying we're going to, right, with a business investment goal in mind. We want to induce people to invest. we're going to tie the agency's hands for a 7-year period so it can't, so that it
Yes.
can't
And they balance
approve.
that with if there's a drug that's better for consumers and patients and people, if it's clinically
it ju-
superior, we are going to allow that because it's good for, in the grand scheme. So
It-
they're trying to balance encouraging, the drug to be developed while also not making sure that better drugs are going to be kept out of the market because that's not good for patients.
But remember, there really is a balance here. My friends are focused only on the sort of follow-on drug portion of the balance. They're not focused where I started on. There are thousands of drugs, or thousands of diseases affecting millions of Americans that have no drug treatment. The goal is to induce investment for those diseases. And a business person is going to say, well, okay, great, what do I get? If the drug's designated and it's approved, what do I get? And the
Well, there's
lawyers,
a chance that nobody's going to come up with a clinically superior drug, and then you've got the whole 7 years. But if somebody does, you're taking that risk.
they're already taking on enormous risk. And what Congress was trying to create was a sense of
But
certainty.
clearly, all the drug makers know about the definition of same drug and the way such drug has been interpreted all these years.
And through all these years, Judge Pan, up to 2017, and here I keep trying to talk about the context around DPAMED. And DPAMED, of course, is all about serial exclusivity. FDA had barely done these kind of breakthrough applications of the statute. They claimed the authority to do it. We found, and the administrative record reveals, 4 instances, the last in 2002. That's why I don't think Congress was thinking about this application. It was thinking about what was in litigation, what FDA said in a post-DPAMED statement that's published in the Federal Register. Let me grab that for your honors. I'll find it when I stand back up. But what they said was, we have a huge problem here. We need the ability to limit serial grants of exclusivity. They went to Congress. We don't know exactly what FDA said to Congress, but what the legislative history reflects is a member of Congress saying, here's what we understand this change to do. It's to address the serial exclusivity problem while maintaining incentives to innovate. I don't think Congress thought they were
But you
touching.
still have an incentive to innovate because you don't know that somebody's going to come up with a clinically superior drug.
You don't know, but you clearly inserted more risk into what's already a risk endeavor.
But isn't that the way it
proposition-
always was before? I mean,
And
wasn't
that's
that
what they'd barely done.
So I'm sorry, are you telling me, my understanding is that before this amendment, it said such drug, but the agency interpreted that to mean same drug as it's defined, which includes clinically superior, that clinically superior aspect of it. Didn't all the drug companies know that?
They knew that FDA had claimed that authority. In 2017, they would have known
That's
that.
something you have to take into account before you start investing in developing an
Right.
orphan
And in
drug. It's part
2017,
of
they
the
would have
regulatory scheme.
known that it had been 15 years. FDA hadn't done it. And now if someone goes.
Wait, I'm sorry, 15 years FDA has
Okay, so
not applied this
to,
definition?
from 2002 to 2017, so far as the administrative record reveals, FDA did not use the such drug, same drug move to break through an unexpired period of exclusivity. So Judge Jackson.
Let me ask you, so you're saying that from 2002 to when?
Up to 2017 when Congress revises the statute, right? It hadn't.
So you're saying that in 2017, you believe that the statute, that change does not allow you to break the exclusivity period?
Absolutely.
So let me just make sure I understand the record in what the district court said in its opinion. In going through the history of these drugs, it said that your client received approval for a drug called Xyrem initially in 2002. And then in 2005, it got approved, Xyrem, for a new indication And then in 2018, the FDA approved Xyrem for the treatment of EDS or cataplexy in narcolepsy patients 7 years or older. That's at page 15 of the district court's opinion, JA 548. Is that all correct?
To my understanding, yes.
And so then Jazz develops a low sodium alternative to Xyrem, and that's the drug that's at issue here, this Xywav, right?
That's right.
And it gets approval in 2020, and it gets exclusivity based on a finding that it's clinically superior because it's low sodium, right?
Yes.
So doesn't Xywav essentially break the exclusivity period that had been established in 2018 of Xyrem?
No. Subsection A is clear that it limits only approvals for a person who is not the holder of such approved application or such license. So Congress is not tying the hands of FDA as to the same sponsor. You get one exclusive approval. It doesn't bar that same company from getting another approval. It operates as to other companies. But I do want to, you touched on the approval for different indications. And I think this is another indication that Congress was not using same drug as FDA had. FDA's action words were same drug for the same use or
Can we just
indication.
go back to what Judge Wilkins just said? I want to make sure I understand this. It seemed like what he described was an application of the same drug definition from the regulation to this context. You said that hadn't been done between 2002 and 2017. And it seems like they said they gave a new period of exclusivity because it was clinically superior. So that's a new drug. So if somebody else other than your client had done it,
So
would they be entitled to the same thing that your client got?
two distinctions, maybe three. One is Judge Wilkins was asking about a 2020 occurrence, so 2020 approval, not 2017. Two, it's not an application of the same drug definition in the regulations. It's an application of subsection C, which by then was on the books. So subsection, that's exactly what subsection C1 says. Is there any already approved licensed drug that's the same? Yes, because Xywav, the new drug, and Xyrem, the prior approved drug, both use oxybate.
That's otherwise the same.
That's otherwise the same. That's otherwise the same at the designation level. And so in order to gain an exclusive approval, so a marketing exclusivity, Jazz had to demonstrate that Xywav was clinically superior to Xyrem under the definition in C2. That's why, Judge Pan, I don't think there's anything confusing about C1 if you just read the words for the words. The confusion comes in when you try to do what they're doing and say, oh, well, the same drug has the old regulatory meaning. Well, actually, it doesn't have the old regulatory meaning. Actually, it creates surplusage. All of those problems come in when you depart from the plain text and go down the ratification worm. Read on its face, this is a very simple statute.
So let me make sure I understand you. Are you saying that even though it has been presented to us that the longstanding understanding of such drug was that it equals same drug, are you saying that that actually isn't the long-running understanding because it never came up and was not applied between 2002 and 2017?
I'm not saying FDA understood the words the same drug, just as you said, it's in its regulations. What I'm saying is, I don't see evidence on the text of the statute that Congress applied the
Would
same.
you dispute that, though, that it was sort of common industry knowledge that such drug equals same drug under the regulatory definition?
I think people know what's in the regulations. I think people understood that FDA had.
But you would have to understand, I mean, such drug was the wording that was used in subsection A.
Yes,
But it was being
and-
interpreted to mean same drug
Yes,
as defined in the regulation.
and people took.
And the arguments we're getting is that everybody understood this, Congress understood it. Are you telling me that that wasn't the understanding?
I'm not saying that wasn't the understanding. I'm saying that people took FDA to court over this. Then the question is, what did Congress mean to do when it revisited this subject? What did Congress mean to do when it revisited this
So you
subject?
don't dispute that the regulatory backdrop was that the common understanding was that such drug was being interpreted as same drug by the agency?
I don't have an empirical view on what people knew. No,
Empirical view, it's
saying,
just that when you apply this, I guess the Monsalvo case came out and they're saying we have to look at the regulatory background and the regulatory backdrop. And I'm just asking, do you contest that the regulatory backdrop and understanding was that such drug equals same drug under the regulatory definition?
it was in the regulation. That's how FDA defined it. I'm not disputing that in any way.
And
shape,
that, and
or
everybody
form.
understood that to be the
I
regulatory
don't know.
backdrop.
I don't know that everyone understood that. And that's, and many
You
people,
don't dispute that.
many people disputed that it was correct. Judge Pan,
No, people might dispute that it's correct, but everybody understood that that's the way the agency was doing this.
and but then the question, the ratification question is, was Congress focused on this application of the same drug to break unexpired periods of
Correct. And Monsalvo says
exclusivity?
we assume that it was.
Monsalvo says one, if they start with a textually plausible competition. Does days mean how many days does the earth go around the sun? Or for filing, is the government office open? And but then they critically.
The understanding was you get the extra
And-
day after the weekend.
and the-
And the parallel argument here is that the understanding was such drug equals same drug, meaning clinically
And
superior.
then Monsalvo
And then
goes,
they put it in.
and then Monsalvo goes on, and it says, does it fit with the text? Does it fit with the text? And what our point is, there they said, we looked at the text, we looked at the rest, we found no indication.
But same
that doesn't
drug
fit.
does, 'cause
What?
There's a regulatory definition.
So does same drug fit with the, no, it does, and that's.
Same drug fits with the text in the context of the regulatory scheme because there's actually a definition of same drug that is consistent with.
But I don't think this,
reading.
but it's not consistent. That's my CU1 point.
You're
That's
looking
my,
only at the statutory language. I'm saying, what do we do with the regulation?
right. The question, the ratification question is, does the regulation plug into the statute in a way that makes sense in terms of text and context? I'm saying no as to context because it revolutionizes the statute. It gives the FDA discretion, broad discretion. They say there's no one general standard for a major contribution to patient care superiority, no one applicable standard. So that's an enormous amount of discretion that they give themselves in a statute that says FDA may not, and it doesn't fit with the text. It's the FDA's language wasn't just same drug, was their action language was same use, same drug for the same use or indication. Congress used the language same drug for the same disease or condition, so they're not actually using the same action phrase that Congress, that
So
the
what's your
FDA used.
definition of same drug?
But it is the drug designated under section 360BB of this title. It's not a defined.
So why isn't the follow-on drug a different drug because it's clinically superior? That's different.
It's they both of them. So the question is, what does Xywave exclusivity block? It
No,
blocks
I'm asking you, what's your definition of same drug?
it's the drug designated. And here,
Right, and
so it's a
not
matter
the
of
same drug designated has a different formula and it's clinically
No,
superior, which makes it different.
the FDA is absolutely clear about this in the administrative record. The drug designated is oxybate. That's where they designate.
And this new drug,
Is also an oxybate drug. And the scope of the blocking effect is determined by Xywave's exclusivity. And again, that's crystal clear on the face of the statute.
well,
What
the
they're,
statutory language doesn't necessarily support that.
It-
See,
it-
if you're going to your statutory language, you just want to go to the meaning of same drug. It seems to me that the second drug is not the same because it's clinically superior. It's different.
I think everyone agrees that sameness is, well, same in what respect?
Ah.
The statute tells you.
And now we're
The
going back to
statute
everyone
tells you.
agrees. Everyone agrees that before this amendment, such drug meant same drug.
And no. Everyone agrees that that's how FDA thought of it. The question is how Congress thought of it. It has to be how Congress thought of it. We're reading a statute. And we have to understand what the words mean in the statute.
Can I come at this from a different direction.
Certainly.
I want you to look at 360 CCE,
Sure.
the demonstration of clinical superiority standard.
Yes.
And then there, it says that the FDA, in order to assist a sponsor, shall notify that sponsor of any plausible hypothesis offered by the sponsor and relied upon the secretary that the drug is clinically superior to a previously approved drug. This is as a basis for designation, right?
Yes.
And this gets me back to kind of like where I started. Congress did not amend the designation section in 2017. It only, which is 360 BB, it only amended 360 CC, which is this approval
That's right.
section. So Congress here in this subsection E is seemingly ratifying a restriction on designation, right? That says, you know, under some circumstances, the secretary is only going to designate a drug on a plausible hypothesis that the drug is clinically superior, even though the designation section doesn't say anything about a requirement of clinical superiority, right?
That's right.
That only comes from regulation.
That's right. And so when we start you, Judge Wilkins, with the beginning of subsection E, to assist sponsors in demonstrating clinical superiority as described in subsection C. So this is all about the serial exclusivity application, not the breakthrough application under A. Congress is laser focused on serial exclusivity all the way through this section, the legislative history.
Well, just because it refers to subsection E, that doesn't tell me that it's referring to serial exclusivity. I mean, that just begs the question. I mean, the whole case is about the subsection E applying only to serial exclusivity or can it break in, so to speak, an existing exclusivity period.
But
I guess my point is this, I'm not trying to be obtuse here, is that even though Congress only amended 360 CC, what they did impacted this other section, 360 BB, and seemed to have ratified FDA's practice of saying that we're only going to designate a drug where there is an existing exclusivity period because another drug has been approved for that rare disease condition. We're only going to designate it. I'm not talking about approval. We're only going to designate it if there's at least a plausible hypothesis that this drug is clinically superior. That wasn't in the statute anywhere, but the FDA was doing that. And Congress in 2017 seemed to have kind of like blessed that regulatory structure.
right. I think I understand, but I don't think that sheds any light on what subsection A means, because you can have a follow-on drug that may be entitled to its own period of exclusivity after a period of exclusivity is expired. So there are previously approved drugs that count under subsection C, but none of them have an existing period of exclusivity. Nonetheless, whether or not the period of exclusivity is ongoing, or rather, even if once it's expired, the question of whether there's serial exclusivity still turns on clinical superiority under C. So it's sort of once for all time.
Can I ask you a question to follow up on Judge Wilkins's question? Under subsection E2, he was
Mhm.
pointing to E1.
Yep.
I don't understand why subsection E2 is not inconsistent with your position, because it says, upon granting exclusive approval or licensure under subsection A on the basis of a demonstration of clinical
Right.
superiority as described in subsection C, shall publish a summary of the clinical superiority findings. Doesn't that contemplate that under A, there's an exception for clinically superior drugs?
Not at all. What you get under C1 is exclusive approval or licensure described in subsection A. And so then it's asking whether if C1 is satisfied and the agency identifies the reasons why C1 and then the clinical superiority requirement C2 is satisfied, it shall publish a summary of the clinical superiority findings. It's in no way inconsistent with our reading of subsection A, which again is just a straight reading of the text and one that aligns with how the 11th Circuit understood the neighboring words in the statute for the same disease or condition in Catalyst. It said, oh, well, that's obvious. It just reads back to for a rare disease or condition. And so the alignment of what the district court here, how it read the same drug as ratification right next to what it then subsequently concluded in a different case called Neurelis is a refer back is really jarring. So surely
Let me just say this to kind of maybe bring this to a close, at least for my purpose. My colleagues may want to continue. The FDA, prior to 2017, was doing a couple of different things with exclusivity that seemed to be beyond explicit words of the statute. One was saying, we're only going to grant serial exclusivity if your drug is clinically superior. And to get there, though, they restricted not at the approval process, but at the designation step by saying, we're not going to even designate this drug unless it's clinically superior, because if it's designated and then you get approval, you automatically get exclusivity. So the way that they were going to kind of try to like stop that from happening, additional exclusivity for everybody is to say, no, we're only going to designate you in the first place if there's at least a plausible hypothesis that you're clinically superior. So that's nowhere in the statute, but that's what the FDA appeared to have been doing, right? And then the other thing it was doing that wasn't in the statute was saying, yeah, the statute says you get 7 years of exclusivity, but if somebody does come along with a drug where they prove their plausible hypothesis that the drug is clinically superior, we're going to give them exclusivity and break the 7-year exclusivity of the previously approved drug. We're doing both of those things, even though neither one of those is really in the statute. You say that Congress clearly blessed and ratified the first, but not the second. And my question to you is that these things kind of go hand in glove. So why should I find that Congress was only blessing one and not the other?
A couple of points. I'm going to try to be very brief. They don't go hand in glove because they're really aiming at two different objects. The subsection C limitation, what Your Honor described as the first unblessed application of the statute, limits how many sponsors can get exclusivity without demonstrating that they've really made an innovative step, right? So it's a limitation on the subsection A grant of marketing exclusivity. The grant of marketing exclusivity is the inducement to come into the area in the first place. So I think it's perfectly conceivable that Congress said we want to limit subsequent grants of exclusivity for the same drug to treat the same disease or condition, because in many circumstances, there's nothing innovative going on, just blocking new entrants for no reason. But also that they would have said, this 7-year period, this is the key inducement. This is how we're bringing drugs to market. And if we don't have this, we know that many of these rare diseases will never get treatments. They're complex, the market's small. So then I also want to, and I'll close with this unless there are other questions. I think that Judge Wilkins, you said something about the pre-2017 framework that's not quite right. So what FDA did was at both the designation and approval stages, use the clinical superiority idea. They use the clinical superiority idea at the designation stage to say, you need to have a plausible hypothesis of why this will be clinically superior. That raised, to my understanding, no particular statutory concern because FDA had expressed rule writing authority under subsection B. In Eagle, this court said, well, you've got a lot of discretion here under subsection B. So they were using that authority. Then they turned around at the approval stage and said, you got to prove up clinical superiority. And that's what was nowhere in the statute. And my submission here, quite simply, is it's still nowhere in the statute under subsection.
Thank you. Yeah. Springer.
Thank you, Your Honors, and may it please the court. Brian Springer on behalf of the federal government. I'd just like to pick up on the regulatory history that has been the topic of conversation this morning. For decades, FDA has recognized that determining whether two drugs are the same drug requires looking not just at the core molecule, but at the other ingredients and the formulation that can make a drug clinically superior. That's always been the correct way to understand the terms used in the Orphan Drug Act, and Congress's statutory amendments in 2017 made clear what was already plain from the language. I think in this case, Jazz seeks to equate its drug to Avadel's drug by focusing on one chemical similarity and ignoring the many consequential physical differences. Although both drugs use oxybate, Jazz's drug is a liquid that's available for absorption immediately, while Avadel's drug uses a proprietary blend of coated and uncoated granules to facilitate a release over an extended period. And the real-world effects for narcolepsy patients are profound. While narcolepsy patients have to wake up in the middle of the night to take a second dose of Jazz's drug, they can take Avadel's drug once before they go to bed. And so both in common parlance and under the statute, these drugs are not the same drug, and the differences matter for patient care. I'm happy to start wherever the court thinks would be the most helpful, but it's...
Well, how is it that when the statute at 360 CCA says that except as provided in subsection B, there's going to be this exclusivity period. And then subsection B has two exceptions that don't apply here. And instead, we have this condition of clinical superiority and it doesn't refer back to specifically to subsection A with respect to knowing whether we're talking about a serial application as opposed to kind of breaking an exclusivity period. It would have been so much easier for Congress to have just called this an exception or made clear that notwithstanding subsection A or some sort of language like that to make clear that we're breaking an exclusivity period, but it didn't do any of it. So why should we essentially read subsection C as another exception when Congress didn't call it that?
So, Your Honor, I don't think it's right to call it another exception to exclusivity. This is a determination of what the scope of exclusivity is in the first instance. So subsection B is about when someone comes in with the same drug for the same disease or condition. In certain circumstances, they can break the exclusivity. They can still come onto the market even though there's an exclusivity that's blocking them. What we're talking about here is an understanding of what is actually blocked. And that goes to the question of what is the same drug. And I would just point the court to, subsection A's language. And again, this is the language that Congress adopted directly from, the term that Congress took from FDA's regulations that had a definition and have had a definition for over 30 years. But if you look at subsection A, it talks about approving an application filed pursuant to section 355 of a drug designated, and then says that, to the extent that that happens, FDA is prohibited from approving another application under that same section for the same drug. I mean, if you look to section 355, there, the analysis that FDA is doing in determining whether to approve an application is approving the whole drug. It's not focusing on just the core molecule.
So you say that this is really about the scope of the exclusivity, right? Well, there had been previously, prior to 2017, a regulation on the scope of exclusivity. And I'm talking about 21 CFR 316.31. Are you familiar with that regulation?
In general, yeah, I am, Your Honor.
So it points out that that FDA may approve a marketing application for a designated orphan drug for use in a rare disease or condition. And then it says FDA will not approve another sponsor's marketing application for the same drug for the same use or indication before the expiration of 7 years, except, and then it's got these exceptions: withdrawal, consent, failure to be able to essentially meet market demand, et cetera. So it's written in the same way as the statute in that sense, in that it lists those as exceptions, and clinically superior isn't like an exception, right? That's in this regulation. So, but it's a regulation about the scope of exclusive approval. So if you're saying that this 2017 amendment was also about the scope of exclusive approval, then how doesn't this regulation kind of undermine, I guess, your position in the sense that the regulation that set forth the scope of orphan drug of exclusive approval doesn't I guess it has to rely on the otherwise the same drug definition to get you there from the regulation?
So, Your Honor, the reason that it leads to the same place is that the regulation that you read that says, FDA is prohibited from, among other things, approving an application for the same drug, that phrase, the same drug, is the one that is defined in FDA's regulations to mean the same active moiety and not clinically superior. So the phrase, the same drug, that appears in that regulation and then that Congress added directly into the statute is defined exactly in that way to bring in the idea of clinical superiority, which is the way sort of in ordinary parlance we think about drugs, that one that has different ingredients and a different formulation and works in a different way can be a different drug.
Your friends on the other side say, though, that if you use the definition of same drug from the regulation and you just tried to plug it into the statute, it wouldn't make sense. Because the verbiage is a little different, talking about, I think, use or indication instead of disease or condition, et cetera. What's your response to that?
Your Honor, I mean, a couple of responses to that. I mean, I think kind of the overarching response is I don't think they actually really point to anything in A that creates a problem. They do talk about C, but the district court explained how, you know, you can understand what FDA was defining here to talk about a drug that sort of looks the same at first blush, but then you determine is clinically superior, and therefore, you know, it might be otherwise the same, but it's not the same drug once you determine the clinical superiority. And I understand my friends to also be talking to this separate portion of the regulation that I think Your Honor also read about same use or indication, but that sort of pertains to a different phrase, the phrase same disease or condition, which is an issue in this case and is presented in a different case that's pending before this court. And I would encourage the court to just look at, you know, the phrase, the same drug, which again comes directly from FDA's regulations that has, you know, long had this regulatory definition.
Can I ask you just a real world question? We're in year 5 of Jazz's exclusivity and year 2 of Avadel's exclusivity, right? How does that work? Are they sharing the market? How does that work?
So, Your Honor, my understanding is that in general, that's right, that they're sharing the market, and that, you know, I think that I believe that Jazz's exclusivity expires in 2027 and Avadel's goes until 2030. So they're both allowed to be on the market now because there was nothing that was blocking Avadel's drug from being approved, but they each have exclusivity that, you know, goes for whatever time they have.
All right.
I think Judge Henderson's question raises a real question. So how is it exclusivity if you're not really exclusive?
So, Your Honor, again, the question is the scope of exclusivity, and everyone, because, you know, in particular, because of FDA's regulations, everyone has known since, you know, at least 1992, that the right way to understand the scope of your exclusivity is that if someone comes along and develops a clinically superior drug, they can get approval and come on the market. And that's the whole point of what Congress was trying to encourage here, was to have drug sponsors create drugs, you know, create better treatments for rare diseases and or conditions. And that's exactly the way that this plays out under FDA's regulatory definition. And again, the term that has now been put directly into the statute.
So if there isn't exclusivity, anybody can come on the market and market the exact same, not clinically superior formulation that you're marketing?
Your Honor, my understanding, right, is that the exclusivity is what's doing the blocking of, you know, an approval of a drug that looks the same.
So it's not an orphan drug, it's just any old drug, and you get approved. People can start making generic versions of your drug immediately?
I'm not sure I'm understanding. I mean, I think the answer is yes, in terms of, so this all arises just in the context of orphan drugs. And if your orphan drug is designated to treat a rare disease or condition, when you get approval, then for 7 years after that, FDA can't approve a follow-on.
I understand how this works.
Yeah, maybe
So I guess
I'm
after the
misunderstanding.
patent, there's some other way of protecting it. Other people can come in and start making the same thing.
That's correct, Your Honor. If this protection were not there, but because the scope of it includes the idea, you know, from the phrase "same drug," that someone who develops something that's clinically superior can come onto the market.
And so for
there's
these two
nothing.
drugs, nobody else can come in using oxybate unless it's clinically superior to both of them.
That's correct, Your
at this
Honor.
time.
That's correct.
Well, then did Xyrem have to be clinically superior? It didn't, did it, with its serial 7-year exclusivity periods? It was either treating a different range of patient or different condition.
That's correct. It was both treating different patient populations, and also it was the same sponsor who was coming back. So the same sponsor can come back. They're not blocked under the text of A.
All right,
So we'd ask the court to affirm. Thank you.
thank you. Let's see, Mr. Perry?
May it please the court, Bill Perry for intervenor Avidel. In 2017, Congress did not silently overrule 25 years of regulatory history by choosing to adopt the precise terminology that FDA had been using throughout that term. I'd like to show how extensively Congress borrowed from FDA's regulations in 2017. Of course, we start with the phrase same drug, which appears in the key statutory provision, which is 360 CCA. But that's only the starting point. What Congress did was adopt the subsidiary definitions from the regs. So it's not.
Let me just interrupt you right there. Congress didn't just put in the word same drug, right? It put in the words, let's see, let me just make sure I have it. Same drug for the same disease, right? That was the phrase that it used instead of such drug for such disease or condition, right?
I'm sorry, I don't mean to cut you off.
That was that key amendment, right? It omitted such drug for such disease or condition and substituted the same drug for the same disease or condition.
It put same in the place of such with respect to both of those terms.
But there's a phrase there, I guess. I just want to get your response to the fact that like the scope of exclusivity provision that I was asking your friend about earlier, which was 316.31, uses the phrasing the same drug for the same use or indication. So it does not use the exact same phrase.
It is different.
Why shouldn't I be concerned about that?
Because that poses a completely separate issue, not here before the court in this case. It was an issue, that is use or indication or same disease and condition in the Catalyst case. And here's what was at stake in that case. There was no question about it being the same drug. It was. The drug had been designated for a disease called LEMS. The second drug came along also for LEMS, but with a separate indication or use. And FDA wanted to split this notion of same disease or condition into subparts and give different exclusivities, right? Every drug, when it goes through this orphan drug process, as Your Honor knows from the designation, is identified in connection with a rare disease or condition. That's where this same disease or condition comes from. Completely different for same drug. What happens at the designation stage is that you come forward and you say, I think I have a drug that I want to get approved ultimately. I want to take advantage of the various benefits Congress has provided if you're designated, including tax breaks for the development of the drug, ultimate chance at exclusivity, and all those sorts of things. Of course, you don't just identify what your active moiety is. You go through the statute and the regs and identify everything you know at that time about your drug. And then you also have to, if you're the second one along, show a plausible hypothesis of clinical superiority. That is that your drug, which you're intending to make, is going to be different than a drug that's already approved. As Your Honor noted, that's an E1 of CC, what Congress just did in the 2017 amendments. And so what's going on here is you have two very separate issues. One is, what does same drug mean? When Congress in 2017 put same drug in this statute, did it mean to embrace the regulatory definition, which I would like to say it obviously did for all the reasons I'm about to explain. But then a completely separate issue, which was addressed in Catalyst, about whether the FDA can split orphan drug designations for the same disease and condition among separate uses or indication within that same disease or condition. It can't, but it is appropriate to look at same drug the way that the regulations did. I think your question to my friend earlier was something about the exceptions. In other words, why didn't they make CCC an exception? And here's why. Because the threshold issue to get to an exception is whether two drugs are the same. When they're not the same, there's no point in going to an exception. Now, for 30-something years, FDA has operated with the definition of same drug from its regulations, which, as you know, is a combination of active moiety and clinically superior. The subsidiary definition of clinically superior includes significant therapeutic advantage, greater efficacy, greater safety, major contribution to patient care. Every one of those terms from the FDA definitions appear in the 2017 amendments. Every one. It's not ambiguous what they were doing here. They were adopting the regulatory structure that FDA had in place. They were preserving that structure. Now, I think it's appropriate, as this court has already done, to focus on E1 and E2 of the statute. They're very important because they show how Congress thought all these pieces would play, how they would work together. Your Honor, first identified E1, which is essentially endorsing the plausible hypothesis regulation about how the designation works. The designation stage, which is often years before the approval stage under 360cc. You don't necessarily know what the drug is at that stage. But you still, if you're the second sponsor to come along, have to show a plausible hypothesis, importantly, of clinical superiority. Congress was adopting that concept. But E2 is perhaps even more important. It tells you what Congress thought would happen under 360cc. You're not making some separate judgment under 360cc that you're making under 360cca. They're tied together. Here's what it says. Upon granting exclusive approval under subsection A, that means this decision is being made under subsection A. And that in turn means that it's being made under the definition of same drug. It has to be. And then it goes on here. On the basis of a demonstration of clinical superiority as described in subsection C. What that tells us is that those two sections work together and they have to work together. And it also tells us that Congress thought subsection A and subsection C would both rely on the concept of clinical superiority, which they do. So that's not all Congress did when it adopted the regulatory text. In the statute, it uses the term otherwise the same drug a couple different times. That is a unique term that refers to this two-part definition. It appears 5 times in the regulations, including in the definition of clinical superiority. And it always means that there's a temporal process. First, you look and see if they have the same active moiety, and then later, after further submissions, after scientific analysis, and the court can see how this all played out in the record, in this case, you decide whether the drug is clinically superior. It might appear that the drug is the same drug as another drug when you're just looking at active moieties, but you have to run out the ground ball and do the rest of that analysis. And that's what subsections A and C do together. The case law that we've cited from the Supreme Court and this court, I think tell us what we're supposed to do in a circumstance like this, when there's been such a huge reliance by Congress on the regulatory history. Of course, Monsalvo Velasquez, maybe 2 weeks ago now, says when there's a longstanding administrative construction, you generally presume Congress meant to adopt those regulations. That presumption was all but dispositive in that case. CFTC versus Shore says in this type of circumstance, using that regulatory construction is, quote, virtually conclusive that Congress meant to employ that. These are all canons, rules of interpretation, presumptions. We cite 4 cases or 3 or 4 cases from this court over the last few years, all.
Your friend on the other side points out that it might be pretty conclusive that they were dealing with the Depomed issue, serial exclusivity regulation, as far as ratifying that. But it is far less clear that they were going beyond that. And we have precedent that says, you know, we need some more kind of explicit clues.
Well, let me suggest, Your Honor, that the precedent of this court and the Supreme Court are not that you need more explicit clues. In fact, often cited is Justice Scalia's treatise, Reading Law, on this point. And if I might add that to our record here, if a statute uses words or phrases that have already received authoritative construction by a responsible administrative agency, they are to be understood in accordance with that construction. That is quoted, including in Hick Vision, Your Honor. Washington Alliance and Wang v. Blinken, all recent cases from this court. And let me add, if I might, Your Honor, that my friend on the other side had been communicating with the FDA over multiple years before our approval about this clinical superiority issue and how the statute worked. And here's what my friend said in a letter from December of 2022 to the FDA.
It's in the record?
It's in the record at JA 382 to 383. That's the middle of the document. The document starts at JA 377. I'm just quoting here. The clear and direct command of the statute is that the only way for Avadel to break the exclusivity protecting Xywav, it's Jazz's drug, is for Avadel to demonstrate that its drug is clinically superior. In other words, they were reading the statute 2.5 years ago to have the same meaning the district court adopted here. Exactly the same meaning. After the 2017 amendments, they understood that's what this statute meant.
I'm sorry, where was that?
That's in a document beginning at JA 377, and the particular quote is from JA 382 to 383. Now, if I might, Your Honor, I'd like to contest one other thing that my friend on the other side says. It's about the text, the language of 360 CCA. And here, I think he believes that we will take as given that the drug designated is the first of the 2 comparators. You compare 2 drugs to each other to see if exclusivity prevents FDA from approving a second drug. The language doesn't actually say you compare the designations. Here's what it actually says. It says, if the secretary—
What are you reading from now?
I'm reading from, I'm sorry, I'm moving around a lot.
That's okay.
360 CCA. So A begins, and I'm paraphrasing here because there's a lot of excess language for this purpose, but if the secretary approves an application, all right, that's the first comparator. And then the description in 2 prepositional phrases describes what that application is for a drug designated under section 360BB. Still, it's the application that's the subject right there. It's not the drug designated. The prepositional phrase is describing the application. And then the second comparator in that drug comparison is another application for the same drug. In other words, you compare one application to another. That's what textually this section is telling us. You apply the same drug test, which of course comes from the reg. But let me just say this. Even if you applied the test and you used the designation, the active moiety, oxybate, for the drug, for Jazz's drug, we're still different. The second comparator is still different, no matter how you read the first part of that sentence. And Your Honor, I think, correctly noted the plausible hypothesis test, plausible hypothesis of clinical superiority at the designation stage. We're different because we demonstrated at that stage that we met that test. We were going to be clinically superior. And let me say there, the site in the joint appendix for that for our designation that shows we're different is 203 to 204 in the joint appendix. And then the explanation that will shed some light on the pretty significant amount of effort and time that FDA spent on this issue is JA 115 to 125. Here's what they were looking at. They were looking at to see if our drug had a different effect in patients' bodies. That is, it might have had the same chemical, but would it affect the physiology of a patient differently? And absolutely it would. They consulted sleep experts and they looked through it. It was a major contribution to patient care. That's what makes it a different drug. That's important. But here's the third problem with my friend's analysis of the text here. I think you heard him say that if you go to section C, which is the new section called Condition of Clinical Superiority, again, this is described in section E2, he says you can't read that section sensibly. The district court explained why you can't. It's on pages 31 and 32 of the opinion. Also, I would recommend page 30, very important about the meaning of E2. But here's the point. If you just put my friend on the other side's test for what drug means in here, you'd be comparing oxybate, an active moiety, to oxybate, an active moiety, to determine if oxybate were clinically superior to oxybate. That's nonsense. That's not how this works. The way that the same drug test works is it's got two parts. First, you look at active moiety, as I said, then you turn to clinical superiority. And the question ultimately is this drug better for patients? Does it have a different impact upon patients in their body or otherwise? There are a lot of examples in the record of drugs that had the same active moiety but were clinically superior. One that comes to mind is a drug called Valtoco, where it's a treatment for people with epilepsy for cluster seizures where they need immediate relief. Same active moiety in the first drug and the second, but the second you could use through a nasal inhaler, and the first was only administered rectally. And the FDA found that was a really significant difference. It made it a different and much better drug. So this is not only the right test because it adopts very clearly, Congress's intent very clearly to adopt the regulatory structure that had been pre-existing, but it's also the best reading of this statute. You can't just say that because two drugs have the same active moiety, I'm going to ignore all the inactive ingredients and how these actually work in the body. They're the same drug. They're not. And you can't just say any slight difference, an immaterial difference between one drug's application, maybe an inactive ingredient, always makes this a different drug, because that undermines exclusivity. What FDA did was find the sweet spot where you're talking about the effect on patients. That is the best reading of this statute. And that's what Congress recognized in 2017 when it widely adopted the statutory text. The regulatory text into the statute.
All right, if there are no questions, then thanks, John.
Thank you.
I'm going to hold you to 2 minutes unless.
That's more than fair, Your Honor. I have a methodological point, a statutory point, and then a same drug comparison point that I'm going to close with. On methodology, I'm going to go with Justice Scalia at the Supreme Court over Justice Scalia in a book. Johnson versus United States says that if you're going to consider ratification, you have to make sure that it fits the context. Jan says exactly the same thing. And that's why this is ultimately a question of how you read the statute that Congress wrote, not the regulation that FDA wrote. And you have to, before you can take the step of saying they must have absorbed it into what they were thinking, you have to ask whether it fits. Here it would revolutionize the statute, it would untie the agency's hands with a couple of words. On the couple of words, Judge Wilkins, I think you're exactly right to point to how FDA had defined scope of orphan drug approval. That's the action language I was talking about earlier. FDA used the words, the same drug for the same use or indication. The statute doesn't use those words. I understand there's a catalyst versus jazz point, but the point is, for these purposes, they're saying you got to just read it as though Congress absorbed everything the agency had done. but Congress used different words for exactly the same thing. What's the scope of orphan drug approval?
Can
and
you
the-
address the apparent concession in the record that was pointed to by your friend on the other side at 382 to 383? I guess this is a document signed by you.
It
And it
is.
says the only way for Avidel to break the ODE protecting Xywav would be for Avidel to demonstrate that it's clinically superior.
It is, that's what we said, and then we took it back. We subsequently argued to the agency, no, actually, there's no statutory authority for this. That's why it's addressed in the agency letter and all the way up. On the same drug comparison, Mr. Perry makes a point. He says, well, even if you read same drug as referring back up, the two drugs are different, they're not oxybate. That's not how FDA designates. Our reply brief at page 15 addresses the way that FDA designates and also FDA's own explanation of why they at one point used sodium oxybate for extended release oral suspension, the JA203 site, to describe the designation. FDA explained that. And so finally, just to come home, if you look at subsection A and you ask yourself, did Congress rewrite this provision of the statute to create a new exception that hadn't been there before, that Judge Jackson had told them isn't there? You only see a portion of an overlap between how FDA had described scope of orphan drug approval and how FDA defined the term. That's not enough under any precedent of this court or the Supreme. Thank you.
All right, thank you.